take for granted this opportunity to participate in discussions like these that should never be taken for granted. And as we partake in this discussion, dear Lord, let us have clear mind and clarity of thoughts as we contribute to the nation's business. We are at a time in this country where we are called upon to be good stewards of our people. And I pray, dear Lord, that these discussions will bear fruit that can say we are in fact stewards of people. In these matters I ask. In Jesus' name, amen.
Amen. Thank you very much, Dr. Dunn. We have, I see here, apologies from Senator Janice Allen, from Member Carenza Morrison. Anything from Senator Gale? Senator Calvin Gale is going to join us online. I would just like to go straight into the confirmation of the minutes. They were circulated, and I'm taking them as read, and I'm going to ask if Senator Golden Campbell, first of all, are there any amendments that any member might have? And no amendments, no corrections. I'm going to ask Senator Golden Campbell if she'd move for the acceptance of the minutes as presented.
I so move, Mr. Chairman.
Thank you. Another member online would be second for us.
Seconded, Chairman.
Dr. Dunn, thank you so much, sir. And we then go into the business. Matters arising, any matters that anyone might have arising? No matters arising. Then we go to new business, which is a sort of old business, because we're going to continue, and I hope today, if we're blessed to finish going through the review of the matrix, I'm going to ask Mrs. Fiola Evans Roberts to lead us through that process.
Thank you, Minister, and good morning, everyone. There are 3 documents that you should have. There is one that we refer to as the mother document.
Yes.
That was the Parliament's matrix.
That's the heavy one?
That's the heavy one, yes.
All right.
Broad one, yes. There is another one that was sent recently. That's updated submissions from the MIC OSI, Insolvency Amendment Bill. The amendments proposed to the Act are as follows. That's the OSI MIC amendments. They were updated, so a new one was sent. And there is a schedule to the matrix of submissions.
Yes.
All those are necessary for us to go through these
Nice.
sessions today. Yes, there's also the matrix, the amended matrix. It's the matrix of submissions for the Joint Select Committee dated May 28th, 2024. That's another, so that's 4 documents. We are reading. No, you will still need to refer to the mother document.
This is the mother document with the small writing,
Yes.
and it folds over. I have lots of documents here, so give me a minute so I can not get them confused.
Thank you.
And now, so this is my mother document, and now we have, oh, this is the drinks document. Wait a minute. For me. You can go.
So we're reading from the document, the matrix of submissions dated May 28th.
Yes,
But
that's
it will
what you're reading from. And that's the current one that has
That's
just
the
been.
current one, yes.
And then there's a schedule to matrix of submissions,
Yes.
and then there is insolvency amendment bill. And
Those
that-
are the OSI submissions updated as of May 28th. Yes, Minister.
Yes, I think I have all of them, my dear, so we can start. Just to remind members, we had agreed to have the mother document, which is the Bible writing one, the small one, which is, I mean, I imagine that everybody in here has seen a Bible. Let me not assume, but it's a small one. And the one that we're reading from is the bigger writing one, which is the template that says Matrix of Submission for the Joint Select Committee. And it's dated on the left-hand corner top, May 28, 2024. That's the document from which Mrs. Evans-Roberts will read from and guide us through. But if somebody wants to check really what's the background to a particular suggestion or amendment, then the mother document can easily bring us up to date. So those are the two main ones we're going to deal with today. You're on, Ms. Roberts. Mrs. Roberts.
Thank you, Minister. The last time we were here, there was an issue with Section 42B, the new section. Recall that we went through sections 1 to 50, but we were asked to refer to Section 42B, which is a new proposal for the removal of directors and filling of vacancy by the court. Member Hilton has asked us to do further research on it. Yes. After further consideration, the provision is necessary to ensure that every director of a company, in exercising his powers and discharging his duties, shall act honestly and in good faith with a view to the best interest of the company. And this comes from Section 174 of the Companies Act. And the proposal...
Sorry, where are we? I was writing something.
Section 42B, new. The one that I'm reading from, that's the submissions dated May 28th.
Is that 2.1 on the left-hand side in the sections? Your document.
No, Section 42B.
We're reading from this document. Are we starting on page 1?
No.
Oh.
No, it's Section 42B. Recall we had gone through sections 1 to 50.
Okay, good.
But
so this is the full document.
That's
so
the full document.
You're moving it to 42B. All right, I'm with you now, dear. Go ahead.
Yes, Minister. So we're looking at 42B, the new section, because further considerations were asked about that one.
Yes, I see that.
Yes, and we are saying that Section 174 of the Companies Act requires directors to act in the best interest of the company. So this proposal is for, during a company's reorganization, a director who unreasonably interferes with the reorganization would be deemed to be not acting in the best interest of the company. And the international best practice reflected in Section 85(1) of the CARICOM Model Law addresses same by empowering the court to remove this director or the directors in the interim so that the proposal can be successful. So the focus is on the director.
Yes, sir. All right, thank you. Go ahead, Mr. Evans.
Sir, Mr. Chairman, Don Webby here.
Welcome, Senator.
Hi. Minister, my only question is, and maybe you can help me think this one through, that director that is not cooperating with the reorganization, suppose he's the largest or only shareholder of the company, would that affect any decision by the court? I'm not sure if that's a fair question to the team.
The section also provides for the court to appoint someone else in that person's place.
Yeah, and I understand that, but I'm saying if the person is the major shareholder.
Does this law allow does this law allow for that person to be removed, whether they are the biggest or smallest shareholder?
It does.
Yeah, okay.
And the answer is yes.
It does, yes.
Okay, all right. So it doesn't matter if there are 100% shareholder that can be removed.
Senator Webby, the director misbehaves and he or she's gone.
Yes.
Yeah, okay, all right, got you. Thank you, Chairman.
Thank you. Go ahead, Ms. Evans-Roberts.
So that is the submission. That's a further considerations that we have made, that this Companies Act provides for the director to act in the interest of the company, and whenever they cannot, the court should be empowered to remove them.
And actually, that's absolutely true in corporate law, because you're there to represent all shareholders,
Yes.
not just one shareholder. When you act as a corporate body, it doesn't matter how many shares you have to have it act in the interest of all shareholders. And if you're found not to do that, the courts will remove you.
Correct.
Chairman, I will go further than that. I'd say all stakeholders, because that's who we're trying to protect. Because the shareholder may be acting in his own interest, eh?
No, but I'm saying...
As a wholly owned subsidiary. But we have to structure it in a way that we're protecting all stakeholders, including the creditors and others.
Mrs. Evans-Roberts.
Correct.
Does the law, though, say stakeholders? The law tends to say shareholders. Can you deal with the law and let us make sure, because we're making a law, not a policy. What does the law say?
In relation to the proposal regime, though, Minister, under the Insolvency Act,
yes,
that proposal is protecting all stakeholders.
Okay, and so that's what the law says.
Yes.
So, sure, I just want to confirm that Senator Webby's request is right, because if it says shareholders, it's quite different from stakeholders.
Yes.
And I wonder what the courts say about stakeholders rather than shareholders, because shareholders have a legal tie to the company. An NGO does not have a legal tie to the company. Can you address that issue? Who are you addressing? Who do the directors represent?
These shareholders, but this is under the insolvency regime. The company is now in a state of insolvency.
Yes.
The proposal is presented on behalf of all the stakeholders. The proposal is presented for the benefit of the creditors. The proposal is presented for the benefit of all of the shareholders.
All right. So what you're saying is, just for clarity, once the company moves into place of the to come under the regime of the Insolvency Act, the responsibility of the director has broadened from just the shareholders to really taking all stakeholders, many of whom are creditors.
Correct,
So
that way.
Senator Webby, your point is taken, and the Insolvency Act is written, in fact, to make sure stakeholders, not just shareholders, who are being considered and protected.
Okay, thanks. I got you. And because, I mean, one major shareholder in a lot of cases could be actually the government of Jamaica.
Yes.
where they owe a lot of taxes. So we have to ensure that our treasury is well protected. Thank you, Chairman. I understand. I'm on board.
Thank you very much, Senator. Go ahead.
And so at this time, Minister, it's for the committee to decide whether or not they agree with that.
Well, after that discussion, committee members, I am waiting to hear your yea or nay. I hear no nays, so I accept that there will be yeas, and we're therefore accepting this as the committee, and then ask you to move on to the next amendment.
Thank you, Minister. The next amendment is Section 48. At the last sitting, we did not have the schedule.
We dealt with 47.
We dealt with 47, yes.
Yes.
We dealt with up to 50, but 48, when we made the presentation, the sections from the CARICOM bill were not available.
Yes.
Hence the reason for the schedule that's attached to it.
Right.
So that schedule is now attached. And
that's the schedule you referred to earlier.
Yes, yes,
right.
Minister.
And
so
we have that.
It is attached.
What are you telling us now?
So the restriction on disposition of assets, that's sale of property, Section 48, the proposed 82, Section 82 from the CARICOM bill, the sections are there.
Yes.
And if you want us to read it, Minister. because these were not available the last time.
You can just highlight the main ones because it's quite a long reading.
Yes, it is. And this is to enhance the proposal regime. A debtor in respect of whom a notice of intention or a proposal is filed may not sell or otherwise dispose of assets outside the ordinary course of business unless authorized to do so by a court, and notwithstanding any requirement for shareholder approval, the court may authorize the sale or disposition even if shareholder approval was not obtained. So this is now authorizing debtors to be able to sell, dispose of property for the benefit of the creditors, even though a shareholder does not agree. That's not explicit in our act, so we are approving the recommendations from the CARICOM bill for it to be included in our legislation.
All right, thank you very much. And Senator Webby, thank you for turning on your camera when you spoke. And I'm just going to remind members who are online that when you are speaking, you're obliged to come on camera so that we can see you. All right, any comments on Section 48, and especially as it relates to the restriction on disposition of assets, 82.1 that was read as part of the attachment? Any comments? No comments requires, then I'm going to note that the committee accepts the submission of Section 48 as presented.
Thank you. Now we continue with Section 51. From Section 51. And this was an amendment from the OSI, MIC OSI, so we have to, it is now at, the blue writing tells you where to find the subsection, in which document and where to see the provision. So it's in this, the OSI MIC, yes, at page 4.
Yeah.
If you go to page 4, and it is submission number 10, amendment of Section 51 of the Act. So that was presented before. It was not included in the mother document.
Right.
So that is why we now have this to show that it was
This is an amendment to the mother document.
Yes, yes, Minister.
All right.
Inclusion.
Yes, and what do you want to tell us?
This we are amending the section to remove the 21 days.
Yes, to
Recall
30.
that we are amending all the sections referring to the first meeting of creditors being called within 21 days to 30 working days. This is another section to be amended to reflect that. And the committee has already accepted that.
And we have accepted that, so we
Yes.
can move on. The committee just wants to see that this was included
Yes.
in the documentation, and now it is. Thank you. Next.
Section 53, it's a new section recommended by Jambar, and it's also on the schedule to the matrix of submissions, because the provisions were not included in the mother document.
Right.
So the provisions are now on page 2 of the schedule.
Okay.
And this, we agree to this amendment because it enhances the provisions and creates certainty. These are the provisions. Critical suppliers, number 2, on application by debtor in respect of whom a notice of intention or a proposal is filed, and on notice to the secured creditors or likely to be affected by the security or charge, the court may make an order declaring a person to be a critical supplier to the debtor if the court is satisfied that the person is a supplier of goods to the goods or services to the debtor. So what we're doing is, in event there are persons who are critical suppliers to the debtor, the services and goods that they provide are necessary for the continuation of the company. The debtor may apply to the court to declare these persons critical suppliers so that they continue to supply the company, offer them the goods and services so that the company can be rehabilitated and be reorganized.
Makes sense.
Yes.
Comments or objections? None. We accept as a committee and move on.
Section 55 corrects a grammatical error. Naturally should be materially.
Got it, straightforward, move on.
Yes, 56A, this is a new section as well, and also included in the schedule. This is a proposal from Jambar for summary administration to be added in the proposal regime. Presently, there's a summary administration for bankruptcy, but not for proposal. And we agree that there should be a summary administration. Summary administration is for smaller companies, and this would protect the MSMEs and so on. They can also present a proposal, even though the assets and the liabilities may not be the same as the general companies. So it's to provide a summary administration, shorter time,
Yes.
less activities by the trustees.
Less
and
costly.
Less costly, all of that.
Sounds again like good sense. Any comments or objections? None, we move on.
Section 57. Include an additional act of bankruptcy as recommended by the CARICOM model bill, and that is in the mother document.
Yes.
Yes, at page 12. The provisions were provided,
Right.
and we're saying this provides certainty, and which constitutes another act of bankruptcy.
And you're comfortable in our recommending
We are comfortable in recommending it.
Members, any comments or objections? No comments or objections, then we move on.
57.2, reference to 21 days should be 30 days as referred to in subsection E.
That's a
And
30 day.
that's a correction
All right.
as well.
Accepted, move on.
Yes. 59, we're inserting the word "or" before the words "against joint debtors." That is for completion of the sentence.
No
We
reasonable
agree.
member could object to that, so we move on.
Section 60, training of practitioners. This is in the mother document, page 13. These were recommendations by Patterson Mayor and trustee to monitor business. We already provided in section 28, that section 28 does make provision for the trustees to monitor the business. And there is also an amendment that we dealt with earlier that provides for the trustee to monitor the business, already dealt with. And in relation to training of practitioners, it's not an action for the legislation, but Regulation 79 does provide for that. And presently there are training needs being addressed by the OSI for the practitioners. So that's already taken care of.
Sounds comprehensive.
Yes.
Don't hear any objections or comments, so we accept and move on.
Section 73, we are inserting the words containing the prescribed information related to the receivership immediately after interim reports. What happened? The Act provided for receivers to file interim reports, but did not prescribe the details that should be in the interim reports, though it prescribed details for the final report. We're now curing that with prescribing the details in the regulations. So the details for the interim report will be separate and different from the details for the final report.
Okay. Any comments? No objections? We accept and move on.
Page 14 of the mother document. That's section 73, new subsection to be inserted. Codifies the powers of the directors during the period of a receivership. We agree with those sections. That's the practice now, and the recommendation codifies what's
It will be codified.
It will be codified.
And
yes.
it seems to be straightforward. We accept. I hear no objections and move on. 270.
4, duties of receiver. Insert additional words to include receiver's duty to publish appointment in all documents. So we agree with the words to be inserted and on all the debtors' websites related to any business carried on by such debtor where the receivers carrying on such businesses. So wherever the receiver is carrying on business, the notification that he's appointed receiver will be sent and available on all websites, on all documents. That's what that does. Definitely an agreement.
All right. No objections, no comments. We move to 82.
That's a mother document, page 15, section 82. There needs to be consistency in the use of the terms corporation and company. We disagreed with that because company is also a defined term in the
Yes.
Act. What happened is where it's situated, persons miss it sometimes that it is not defined, but it is defined. The word company is defined.
Company is well defined,
Well, and it's
all over the place.
and it's defined in the Act as well.
And so what you're saying about
Though
corporation?
it may be missed. So there is no need to
change.
differentiate.
Okay.
Yes, because company is also defined.
All right. No objections, no comments. Move on to page 15, 82.5. Oh, there's a comment. Can you identify yourself, please? And we need to hear you, so maybe you have to remove the mask while you're speaking. Okay. Well, you have to speak very close to the mic. Yes? No, you didn't tell me who you are and where you're from.
Mr. Chairman, I'm not hearing at all. My apologies, I'm not hearing at all.
No, that can't work. You want to move down forward there to this mic? Turn off that one and move in front of you. Come in front of you, that mic should be working. And then identify yourself and your corporation or company, whichever you prefer, under circumstances, and then tell us.
Erica Simon with the Legal Reform Department. I was looking at 82.2,
Yes.
which looks at two scenarios where there can be an assignment of the insolvent person's property. One case being the corporation and one being the company. What we understood Jambar to be flagging was in relation to the company. It says that there would be a resolution that the company be wound up in accordance with the corporation's constitution, and that is the inconsistency that I think that they were talking about. I think that corporations there should say companies.
So it should be uniform. If
Right.
you're going to use
Because
company,
they're
you use
speaking about the
company.
company, and then also...
I see you're getting a yes, and I completely agree with you.
And also we noted that it's saying would instead of wound.
So it's a spelling error there. It should be wound up rather than would up.
There's a typo.
Thank you very much for those. And I think we agree that if you're going to use company which is defined, then we should be continuous in the use of that company. The moment you bring in corporation, you're bringing a foreign jurisdiction nomenclature, which will cause confusion. We just agree on company. Right, Mrs. Evans-Roberts?
We agree that corporation is used twice and company used once. It's best to just change company to corporation. And the word...
Just a minute.
Yes, in section 82.
One second. You said company is defined.
In the Act, yes.
Corporation is defined in the Act?
Yes, it is, Minister.
And so therefore, it causes confusion if we're not using the same term in this clause. And you're therefore agreeing that we should move, instead of changing everything to company, we change everything to corporation in this particular clause. Is that your recommendation?
That's my recommendation, Minister.
And that then will make it clearer for everyone, and would be changed to wound.
In relation to that, the Act itself has wound up, so it's correct in the Act. I'm not
But
sure.
she's just pointed out that there's a typo here, so we'll fix that.
We're saying that it doesn't need to be fixed. The Act is correct. The Act has wound up.
Okay, just the presentation
So it was
okay.
spelled incorrectly somewhere else, but not in the Act.
Okay.
The Act is correct. So
All
for
right,
section 82, the new recommendation is we agree to change the word company
to
corporation so that it agrees with that subsection.
In this, and you agrees with the definition.
And yes, Minister.
All right. Seems to be clear on that. Can we move on?
Yes. Section 82.5, there is an incorrect spelling there as well, pursuant. We're changing that.
Okay.
Section 83, in the OSI make submission, correct references to the supervisor. And the section is being amended to incorporate that.
Okay, so you're making supervisor be qualified by the definite article rather than the indefinite article.
Correct. Yes, Minister. Thank you.
Okay, thank you.
Page 15, 83.2, amend the section to read special resolution in agreement with the general provision of section 237.
Come on now, Mrs. Evans-Roberts.
Yes, Minister.
It's Parliament. Go ahead, my dear.
Section 237 is the general power to appoint our substitute trustees by special resolution. So in the Act, by Section 237, whenever creditors wish to substitute or appoint a trustee, they must do so by special resolution.
Yes.
However, every other section of the Act, when a debtor appoints a trustee at the first meeting of creditors, they may remove that trustee by ordinary resolution.
Okay.
So it doesn't need to change.
So the creditors just use ordinary resolution.
To remove the trustee appointed by the debtor.
Okay.
But in all other instances where creditors wish to remove or substitute the trustee, they must do so by special resolution.
Okay.
So if the creditors appoint a trustee and they wish to remove, they must do it by special resolution.
All right.
So this is correct. No amendment is required.
Thank you. Next.
Section 83.3, same page 15. It should read, however, the creditors may, in accordance with Section 237, by special resolution, and it is the same as we just explained.
Right.
Yes.
Accepted. No issues.
Section 83.6, the word is missing. Correct. We will insert that.
Good. Next.
15, amend time frame for consistency with other sections.
That's the 30 days?
That's, no, this is not the 30 days. Section 156 has 10 days to give notice of the meeting of creditors.
Yes, okay.
10 days. All other sections, though, have 5 days. So instead of changing 156 to 5, instead of changing the other sections to 10, we are changing 156 to 5 to align with all the other sections.
Okay.
Yes.
So you're going to a shorter time period rather than
Yes,
the
Minister.
10 days.
5 days have been working effectively within which to give that notice. Section
Sounds like
85.
Accepted. Next one.
Section 85, that's an submission by the OSI.
Yeah.
This amendment is proposed since a failure on the part of the trustee to file the appointment. This is the property of the bankrupt to vest in the trustee. The wording is not clear, so we are simply rephrasing for clarity.
All right. Therefore, members, attendees, any comments or objections? None. We accept and move on. 88.
Trustee may surrender lease. This is a recommendation to make clear that vesting of leases is subject to the right of secured creditors. We disagree. Secured creditor does not vest, secured property does not vest in trustee. Section 88 is not consistent with Section 85. This was a recommendation to make it explicit in the Act that secured leases don't vest in the trustee. But it is understood that bankruptcy is always subject to the rights of the secured creditor.
Of course, yes.
Yes. No need to restate that.
All right.
Yes.
Accept and move on. 89.
Receiving order and assignment, amend the word act to removing the capital A to common A, and we disagree. The current capital act makes it clear that a reference to any other piece of legislation. Yes?
You disagree with the
We're disagreeing with the
request?
recommendation
Yes.
to
Okay.
change the capital A
So
to
you're keeping
common.
what you have?
We're keeping what we have.
All
Because
right.
it is to different, reference to different pieces of legislation.
Apparently no objections, no comments. We move on to 93.
Section 93, reference, incorrect reference being corrected. We agree, we disagree with that. It is, the reference is to exempt property, and it is correct.
Good. Checked and correct, and move on to 94.
Yes. The word in is missing, and this is correct. We are agreeing with that. Removing the apostrophe in section 94.3b, that is correct. We are agreeing with that.
Amended, accepted, 99.
Yes, the word entered should be entitled. We agree with that. It amends an error.
Okay.
105, the words after mailing does not provide clarity, are meant to provide clarity for date of receipt of notice. The section is to be amended to provide for the time to start running after deemed receipt of the notices and not after mailing. That's how it is usually done in legislation, that the action is required after the person is deemed to have received a notice. Is
deemed kind of given a range or just a term?
It's a term, it's a
It's a
legal,
term, okay.
legal fiction. It's a term.
Okay, the lawyers don't seem to be objecting, so we move on to 107.
107, make it clear that moral rights are not assignable. We disagree. The section refers specifically to the rights which may be assigned, and as such, the provision is already clear.
Okay, so you keep what we
We are
have.
keeping what we have, yes. Insert the word if at the beginning of the sentence in section 101. We disagree as well. The section is correct as it is.
All right. No
Delete the word is after creditors, and we agree with that one. It amends an error.
123.
The word acted should be acting in 123. We disagree. The word acted is the correct word.
All right, no comments. We move on to 129.
Examination of bankrupt by trustee prior to first meeting of creditors. We discovered that the section 29 deals with the trustee's examination, but a number of the activities for the trustee were located in section 139.
Yes.
So we are amending to both, they go together. We are firstly replacing subsection 1 in 129
Yes.
to make it clear. Redrafted it for greater clarity. And we are removing subsections 2 to 4 from 130 up to 129 because those are actions of the trustee, not actions of the supervisor.
Right.
They were misplaced. Yeah.
And so you're correcting that.
We are correcting that. So,
Good.
yeah.
129, no comments. We move on.
So 130 now is an examination of the bankrupt by the supervisor. Subsections 2 to 4 will be deleted, will be removed, and we're amending the word trustee to supervisor at the end of that sentence.
Good. No comments. We move to 131.
131, the amendment is to widen the ambit of examination by the trustee to include all relevant persons. Presently says trustee may examine bankrupt and others, but section 129 already deals with trustee examining the bankrupt, so we are just amending the marginal note to say persons connected to the bankrupt. The trustee may examine persons connected to the bankrupt to widen the ambit. Section 131, which now the marginal note reads, trustee may examine bankrupt and others.
We just give,
But the trustee already examines the bankrupt at section 129. And section 131 really deals with persons connected to the bankrupt. So we are correcting the marginal note to align with the provisions of 131.
Just a question. 131, 1A1. Persons who are reasonably thought to have knowledge of the affairs of the bankrupt. What's the definition of those persons in law? Who are those persons? Because 131, 182 spells out the clerk, the servant, the officer, the director, blah, blah, blah. Who are those persons reasonably thought that the trustee is empowered to examine?
There is really no definition, but trustees do conduct investigations, and so whoever the trustee determines it has some connection with the debtor, the trustee may examine those persons. You were?
You want to turn on your mic?
Yes.
I was trying to understand practically who those persons have been in your experience. For example.
This could be any persons associated with the operation of the bankrupt business. Example, loans officer. It could be somebody on a joint account. Any person who would have knowledge of the affairs. So it wouldn't be prescriptive to say X, Y, Z, because that would limit the persons, and you want it to be wide to give the trustee the power to investigate as much as is possible to get the information needed.
Thank
All right, thanks for the clarity. We move on. Accept it and move on.
Section 132, the recommendation by JAMBAR to amend to ensure the process covers all the steps required for obtaining a warrant, and we disagree with that based on the provisions of the Act from sections 129 to 136. The procedure is real. The different steps are identified there. The trustee first examines the bankrupt, then applies to the court for the order, and then if the bankrupt fails, the trustee proceeds to apply for the warrant. So the procedure is already clear and sets out there.
All right.
Yeah.
Clear. We accept it. Move on to one.
Apologies, Chair. I'm trying to go back to Jambar's actual
Recommendation.
comment on it, yeah.
Page 20 of the model document.
Page 20.
Page 20.
Why does my matrix not seem to be paginated?
132.
For some reason, I don't have a paginated matrix. My mother document isn't paginated. What, section 132, right. I withdraw, Chair. Thank you.
Okay, you're welcome. Thank you. Section 136C, reference to debtor is to be changed to bankrupt. That's correct. It amends an error.
All right.
Thank you. Automatic discharge procedure. Quite a few amendments here. Amend the automatic discharge procedure by extending the various
We're
timelines.
on 137.
With section 137,
Okay.
yes, Minister. We disagree with the suggestion, the submission to extend the timeline. Presently, it's 12 months. And we want the 12-month timeline to stay in order to ensure that the automatic discharge is granted expeditiously. And it is working so far as well. So all the other amendments, we will not extend it. Importantly, there's a discretion in section 137.1 that the supervisor may extend the time. So that discretion is exercised on a case-by-case basis. There's also the mention of the 14 days prior to expiration of the 12-month period in that section, which is incorrect. So we are amending that to say
what?
There is no opposition to, the way it is written now, the 12-month is applicable to only one section. We are going to amend it so it applies to both.
All sections, okay,
Yes.
good. Seems to be no objection there, so we move to 138.
138, extend the timeline, 30 days to 60. This is associated with the request to extend from 12 months to 24 months, so all the other extensions would follow, but we definitely would disagree with the 12 months, because the 12 months stays, so there's no reason to extend the time. Section 138 recommend that the trustee be the one to apply to court, and this is already addressed. The section is being amended by deleting the word may and substituting therefore the word shall, and also to align with regulation 2353 that says shall.
Okay, just
So we agree with that.
alignment. So one
Alignment.
accepted. 139.
139, extend the timeline in not less than 15 days. Again, this is associated with the request to extend from 12 to 24 months. So we disagree. The section provides for the final notice to be served in not less than 15 days before the date of the automatic discharge. Not a special timeline is there. So what is there will remain. This amendment, there's a further amendment to provide for the supervisor as regulator to issue the certificate of automatic discharge. The current section says that the trustee issues the discharge. It is the supervisor who issues the discharge. So the amendment will be made that the supervisor issues and not the trustee.
All right. 139 accepted. 140.
This amendment will correct an error. The trustee receives as the bankrupt waives the right. Presently, it says that the bankrupt is receiving the waiver, but it's the bankrupt who gives the waiver, and the trustee receives the waiver. So we're just correcting an error.
So you do that switch, right?
Yes.
141.
Reference to supervisor should be trustee. We disagree. The current provision should be retained as subsection 3 gives the supervisor the power to go to court to file a report in court if it is necessary.
Okay, granted. Agreed.
Reference to section 93 is incorrect. We agree. The correct reference is section 94.
Good. That's accepted. And we move to 142.
It's a recommendation from Jambar, meant to be an opposition to an automatic discharge generally, as what is being recommended is a discharge just with conditions. We agree with that. When there is an opposition against automatic discharge, the sections no longer apply, so it is an application for general discharge. We agree with that recommendation.
Good. 144.
Relate the bankrupt's action to his disagreement with the trustee's recommendation. We agree with that, but it was already proposed by the OSI. This section is being amended by deleting the words before the expiration of the 12-month period after the date of the bankruptcy and substituting therefore the words within 10 days after filing of the report. This was an OSI make recommendation.
Thank you. Moving then to 147.
144.
144.
Powers of the court in relation to a discharge. Another OSI make recommendation, which will allow for trustees to apply for the discharge of the bankrupt. As it is now, it may be interpreted as if only the bankrupt may apply for the discharge. We're making sure that the trustee has the power to apply for the discharge as well at the end of an administration. So we're inserting the word "and the trustee" in that section.
Good. So that gets amendment. There was no objection there. We move to 147.
Cessation of any statutory disqualification. The Banking Act was repealed, and so we agree. We can, since we're doing an amendment, make reference to the name of the act currently. And I'm sure the CPC may see others as well in relation to that. Bankrupt to report to the trustee and the court.
That's 148.
That's 148, yes. Another OSI make recommendation. As it is now, when the court makes an order for conditional discharge, the act is silent on what happened thereafter. But a conditional discharge is not an absolute discharge. So the section is being amended to empower the supervisor to issue an absolute discharge after the bankrupt has complied with the conditions. So after the bankrupt complies, the trustee will file a certificate of compliance on the supervisor, and the supervisor will issue a certificate of absolute discharge.
Okay. And we move to 150.
150 reference to A to G is incorrect, and this amends an error. A to H is the correct reference.
And we correct that. And we move on to...
Another incorrect referencing.
Yes.
The correct is IH1.
And debts not released by order of discharge in 150. Continuing.
Yes. 155, Part X. This is an OSI make recommendation. The trustee at intervals advises the creditors how much is available to be paid to the creditors, and importantly, even at that stage, creditors could file a claim on the trustee, but there is no prescribed form for that. So we are amending to make sure that there is a prescribed form so that all trustees provide the same information.
Right.
Yes.
Okay.
Trustee to send notice to the creditors of first meeting. So we are amending Section 83.6 to match the 156, but recall we are saying that 156 is to be amended to 5 days to accord with all the other sections. Yes. And in that section as well, there's an OSI MIC recommendation submission. The amendment provides uniformity throughout the Act to allow for 30 working days as well to call the first meeting of creditors. Recall that that is one submission that has been accepted to amend the time for calling first meetings of creditors. Section 156. 156.5, yes, trustees to send notice, include other methods of creditor participation, and we are happy for this recommendation because this relates to all electronic mediums of communication to allow for virtual and hybrid meetings. Very much so.
All any statements beginning with all and every tends to be wrong. Do you really mean all? Do you mean WhatsApp? Do you mean TikTok? Do you mean what?
That's certainly not.
Okay, so I think you need to consider that a little bit more because all is changing practically every day.
And it's relevant.
So if you put all, you're tying down yourself like every. Yeah. So that has, I don't believe that's a good move.
Mr. Chairman, I think I'm supporting your concern with that because we are in an age of artificial intelligence as well.
It changes every day. It changes every day.
Some of those modes of communication may not be modes that can ensure the security of the meeting, nor for that matter, assure everyone that the person they're speaking to is actually the person they're speaking to.
And also because
that has to be considered.
As these media change, there are people who get onto some media in the early stages, and others are laggards, so to speak. And so you can't say that you're going to catch everybody. So that has to be amended. So you will amend it?
Minister, the amendments proposed here are similar to the ones that we did to the Companies Act during COVID, but it goes further to speak to the methods that are necessary to ensure that everyone is able to participate. There is identification. So the provision itself, which is 150 in the draft CARICOM model, it's detailed. It has rules there to ensure the concerns you've raised.
My main concern is the word all.
Right.
That was
this
just
is
my
not the
comment.
wording. This is just her explanation.
Yeah. That's
okay. So the Act does not say all.
No.
No, Minister.
The Act is specific.
Yes.
It is specific.
An,
He said
an
so.
outline delineates which media will be used and what and how you use it.
How to use it and the rules applicable
Okay.
to accept those mediums.
I agree, Minister.
So we could look at it. It's 150.
We were,
Yes, we're given
yes,
the relevant portions.
it was given the outline.
It's, go to
You have it.
156, it's in the model document, recommendation number 6, pages 3 to 4. The blue writing at the top. The model document,
Yes.
pages 3 to 4.
Recommendation 6, 3 to 4.
You have it, Senator?
It actually reads, may I read it? A creditor may participate in a meeting by means of a telephonic, and electronic or other electronic means communication facility that permits all participants to communicate adequately with each other during the meeting, and the director so participating in a meeting is deemed to be present at that meeting.
That's still too broad. Somebody's going to sue you. Somebody who has, somebody's going to sue you for not communicating with them because it's too broad and unspecific. What you can do is make it broad but specific and say that it will be updated from time to time by the trustee or the supervisor, but until it's updated, what you have is what you have. Because you cannot make it that broad, because I'll sue you. You send it out, and you send it out by something that I chose not to because I don't want to. I sue you.
I don't know if the method that we often use by making it broad but leaving it to an order to specify the means that are approved is an appropriate mechanism in this, but you don't want something that is going to require you necessarily to have to come back to Parliament to do that. Maybe a ministerial order or something you could.
May I suggest that we bring the wording at the next meeting?
Yes.
And then you can assess it to
And
see
make
if it's
it,
adequate. We circulated before.
you hear what my concerns are.
Yes.
And I know that they're real because when money is involved, people find always. And if you give me an omnibus clause like this, I'm going to rip you. Because I'm going to say I wasn't contacted. All right, so make that more specific, and then maybe you can say can be amended from time to time by whoever should do the amendment, but make it very clear.
Guided, Minister.
Noted,
Okay.
Minister.
All right, next.
158, make provisions for 2 or more creditors to petition the OSI to call a meeting of creditors if trustee is unwilling. This is already provided for in section 158. And creditors may request the trustee to convene the meeting as well. Supervisor may also do that.
Yes.
It's already provided for in the Act.
There seems to be no objection, so we accept and move on to 164.
Insert section number, which is missing. Amend.
You're accepting that?
We are accepting that.
All right, and 183?
Duties of inspectors. And OSI make recommendation. It is being amended by inserting next after the words dividend sheet, the words in the form prescribed. This is another form which needs to be uniformed. So we are having one prescribed in the regulations.
Right. You know, I'm very pleased to see that everywhere there's a reference to OSI, there's a Ministry of Industry, Investment and Commerce, because very often agencies tend to feel that they're independent silos but are not related to a ministry, but the ministry, and the association has been working very well. So I'm glad to see that. We accept 183 and move on to 193A, new.
Secured creditors not required to prove claim. The recommendation is insert a new section other than section 192 and section 193. A secured creditor is not required to prove his claim. We disagree. Again, bankruptcy is always subject to the rights of the secured creditors. Sections 192 and 193 are the exceptions, specifies the 2 times that the secured creditor may prove a claim. So these are the exceptions. It is understood that bankruptcy is subject to the rights of the secured creditor.
Again, moving under the umbrella of the OSI and bankruptcy, the rules are somewhat different. And this makes it clear, and you're keeping it. Seems to be no objection, so we move on to
Section
202.
202.
Yeah.
All right, so Minister, 202, it has significant implication because it deals with the ranking of claims under the Act, so we need a little more time with this. So we will
You will come back to us on
right,
this.
at the next
You're
meeting.
working on this.
Right, we are doing the consultation with the practitioners and also the AG's chambers, and we are coming up with something that will be satisfactory to all concerned.
All right. So we
will look at
will come back to 202 in due course.
Yes.
Next.
204, use defined term related person instead of person related. We agree. Related person is defined and is used elsewhere in the Act. This is the only time that it says.
Good. So we fix this and move to 216.
216, replace registrar with registrar of companies. We disagree with that one. The reference is correct. Wherever registrar of companies meant in the Act, it does point that out. Registrar is defined to mean the registrar of the Supreme Court.
Okay, fine. Registers of companies is always used as such.
Yes.
Clear. Thank you. Move on to
final dividend payment requirement in section 2162.
Yes.
Amend the Act to remove requirement for trustees' bills of cost. We do not agree with that. The section requires that trustee accounts are to be taxed, and the document to be submitted is a trustee bill of costs. That is provided for in Regulation 22, 23, 26, and 55. Each time a trustee account is to be taxed, they are to file a trustee's bill of costs. Yes. This is an appropriate check and balance necessary for fairness, transparency, and accountability.
all right, and we know how legal fees can get into court.
Oh, yes, Minister.
Even if it's not in just jurisdiction. So next one.
Also remove proof of payment requirements.
That's number.
That's on section, we're looking at all the recommendations for 216.
Yes.
That's another PwC recommendation. We are saying as well that if payments are made, proof of the payment is required in whatever form, but there should be something to prove that the payments were made. And there is a form 2, that makes it very easy.
All right, so again, easy to manage. 219 is where we're going?
216?
216, the
continues.
second part. Okay, right.
Yes. Recommendation number 4, remove the requirement for taxation of the trustees' account. And there is an entire procedure in there in the Act for the taxation of the trustees' accounts for the same reason above, for transparency, accountability, and it is consistent as well with all other legislation dealing with insolvency, that the trustees' accounts be taxed before he's discharged. So we are keeping that. Amend to provide for the prescribed form as stated in section 2165. We agree as well, though the Act mentioned that there was a prescribed form, there is none, so one is now being prescribed in the regulations. Summary administration includes section in draft CARICOM bill, which allows supervisor to determine that summary administration ceases to apply. It is presently provided for, and this is just an additional information given to supervisor to make that determination. So it will be helpful. So we are agreeing with that recommendation.
No issue there, and we move on in the same section. You have others that you're agreeing
Change
on?
reference from ordinary mail to registered or courier. We disagree. This is the summary administration. Everything at a lesser cost. Yes? So with cheapest method, cheapest route. So we are not removing ordinary mail. Delete unnecessary words if, them, and in 2194F. Agree corrects error 2194.
Same for J, same for K.
Yes.
We
yes,
agree, all
yes.
right? And we move to 223.
223, amend the section to clearly define the role of the supervisor. It's already proposed. This section is being amended to include the power to issue directives, which was in the Canadian counterpart, but was not included in our act. So we're just including
You're just including,
yes.
no issue there. 223 moves us. You have another issue on 223 on the next page.
Include the power to convene the meeting of creditors.
Yes.
And we're saying that the power is already there.
No
we had
problem.
dealt with it earlier.
No change needed.
No change.
223, functions of supervisor.
Yes, that's on.
Is there a repetition?
Yes.
Yes, that's right. I can see that.
226. Recommendation for public records to be available on website. And we agree that the section provides for the supervisor to make records available in such form as the supervisor deems appropriate. Of course, subject to the Data Protection Act now. Plans are afoot to have the records available appropriately, because sometimes the payments have to be made for the records. So
yes.
all of that consideration is being given for that to be done. So we agree with that recommendation. And there is an incorrect reference as well, and we are amending the reference to section 74 instead of 73.2.
Okay.
227, government trustee. All reference trustee should be to the government trustee. Agree. It corrects an error.
Easy agreement. Move on.
Yes, and the amendment, there's another amendment to amend to insert commissions, empowering the government trustee to collect both fees and commissions.
But fees are not from the bankruptcy estate.
That's very important.
Okay. And therefore we agree and move on to 234.
Duality of practitioners. The IA does not prohibit the same person acting as receiver and trustee and meant to provide for receiver to be deemed trustee. We disagree with that one, but there is already a prohibition against what is being proposed in section 234 to prevent conflict of interest.
Okay.
So we will be making specific to the trustee, no trustee who is the receiver of the property of any debtor shall act as bankruptcy trustee in relation to the estate of the said debtor. And this section provides broadly with the permission of the supervisor of insolvency.
But even more
Mr. Chairman, I strongly support that position that has been taken. Strongly support it.
I was about to say, Senator Webby, recognizing that you're from, the highfalutin place of Kingston, and me come from simple St. Elizabeth, and even me did understand, so that is conflict of interest. We can't have that. So I completely agree with you and support you, Senator Webby.
If I may, Sir Chairman.
Thanks, Chairman.
Yeah, another Kingstonite. Yes, MP. Miller.
By the way, Mr. Chairman and colleagues, my dad is from Kedits in Clarendon. Just for the record.
All right. Go ahead, Member Miller.
Sufficing to say that I strongly support it as well.
Yes.
My father is from Manchester, my mom is from Trelawney, and I'm from Spanish Town.
Okay, we cover the country properly. Yeah, very touchy this morning. All right, we're well covered. So, Mrs. Evans-Roberts, we agree and move on.
Section 237, the section does not match with what is said in section 83.2. We agree, and we're going to remove that. No,
okay.
We disagree.
You disagree, I think.
Yes, section 237 is a general power to remove trustees. The provision remains the same.
As it is?
Yes.
We accept that and move on. 238?
There's another amendment in 237, provisions to be made for the supervisor to issue certificate of assignment to a substitute trustee. We agree with that, and it's already addressed in Regulation 20.
All right. No objection seems to be there. For 272, we move on.
238, incorrect reference. We are amending that as well. Agree that
You're accepting that?
We are accepting.
And
yes.
we move on then to 272.
Marginal note is incorrect, and we agree. We are correcting it. The BIA corresponding provision is no personal liability in respect of matters before appointment, and we are suggesting that that be used instead.
Right, and you have
Section
we're on
272.
272.
The marginal note doesn't agree with the provisions. Yeah.
And we have some other comments on the next page for 272.
No.
Establishment of an advisory board for the OSI.
This is a new provision.
It is there.
It's a new.
Oh, it's not a part of 272. Okay, it's a new provision by the OSI. Go ahead, ma'am.
The proposal is premised on the need to enhance and strengthen the work of the OSI, as well as to reposition the organization to further improve Jamaica's
No,
ranking
spend some more time on
internationally.
that and explain for us what you mean to reposition and what is the benefit to those who will use it. Because remember, in all things Jamaica Business Ministry, we're there to serve our clients and citizens. So is it Mrs. Sutherland Reed who's going to tell me what this new exalted thing is going to do?
Okay. So this is not a management board. This is an advisory board.
Yes.
That is intended to
Go closer to the mic, yes.
an advisory board that is intended to support the OSI in terms of their decision making, having the practitioners, having persons with practical experience as well, giving an input, because a lot of time using theory as opposed to actual business persons who can bring another perspective. They won't be making decisions, but they will be giving the competence and experience to inform.
I'll give you an
decision.
example. The Companies Office of Jamaica has an advisory board.
Yes.
The NLA, the National Land Authority, has an advisory
Yes,
board.
as well.
The Trade Board has a board of directors. JAMPRO has a board of directors. So there's a difference there. I see Senator Cavengale wants to come in, but I have a query here just to make sure that this advisory board is indeed appointed by the minister.
Yes, it is.
It is. All right, Senator Gale, that's you.
Thank you, Chair, and my apologies for being late.
We were told that you have other big business and money things to deal with.
Yeah, and I support this approach in terms of its concept. I just wanted to clarify why the advisory board approach as opposed to a regular board of directors, because sometimes an advisory board will be reminded that you are in here as an advisory capacity. And the second thing is that are we to anticipate the structure of the board and its competence in terms of the requirement to be part of the schedule of the proposed amendment to the legislation. So we will look forward for that. But just the clarity in terms of why the advisory board as opposed to a main board.
Okay, so the role of the supervisor of insolvency is a quasi-judicial function. As such,
Start again for me.
right, the role of the supervisor of insolvency is a quasi-judicial function, which should be independent. It's not a function that should be influenced directly by any person, and so that is necessary to allow for independent decision-making. As it relates to the schedule in the Act will provide for the competencies, all the competencies and the details as to the structure of this body.
Also, I understand what Senator Gale is asking about. Who should be on the board, and you must have two from this organization. I don't so much favor that. The minister is seeking advice to the board. The minister is accountable to cabinet and parliament, And if he has that job, he should know how to choose the people on the advisory board. Because what happens, Senator Gale, we make a law, and we're making a law that should last 25, 30 years, maybe with amendments. And things change. We name an organization, it might even exist anymore, and the role that it has changes. So the minister should be given that choice to make the appointment to, and especially an advisory board. But are you willing to go along with that?
That's the essential point. Since the mere fact that it's an advisory board, and you would have indicated the level of independence that is being pursued, then I'm suggesting that you leave it to the construct of the minister to decide. And then the minister can identify the level of competence with the recommendations, of course, from the institution. So I'm in agreement with that kind of approach, Chair.
So we agree on that. Senator Golding.
Chair, I think I'm not.
I didn't mean Golding Campbell, so you know what I
mean. I would ask the team to talk a little bit more about what this advisory board is actually going to be advising on, because proposed functions listed as advising the supervisor on insolvency on strategic and business planning responsibilities of the office.
Let me try and answer that for you, because I'm in that position to make that appointment.
Well, 1 second, Chair.
Yes.
Let me just
You're talking
this.
legally or?
Well, not so much, because the board is going to have functions to 3 different persons under what I'm seeing here. One, it's going to advise the supervisor on strategic planning and business planning. Then it's also going to advise the minister on matters of general policy relating to insolvency. And then it's also going to advise the office of the supervisor generally in relation to the implementation of government policy on insolvency. How does an advisory board, not employed to the government, advise the office, who should contain the competent professionals who are placed there to implement government policy? How does the advisory board advise you about how to implement government policy? It would seem to me that as a director of the board, I look to my management team to advise me as to how they're going to implement a policy.
And this is exactly why it's a good question, because here you are, you're dealing with insolvency. Remember, we discussed before stakeholders rather than their shareholders. And when you have stakeholders, you have a range of people that have to be considered. And the minister appointing properly would choose people from business, sometimes the church, sometimes a headmaster, depending on what you wanted, maybe sometimes a senior union leader or 2. So you give them maybe sometimes a lawyer, sometimes a professor. However that minister feels it might turn out in the next 3 to 4 years when they might meet, they give advice, and their wisdom is there. Now, I tell you, sometimes a not so wise CEO might ignore them. They ignore them at their peril, because here you have all these really smart people with all that experience. You call them together every month and say, hey, this is what we're dealing with. What's your thought? You may or may not take what they give, but it's worthwhile, because insolvency and bankruptcy is emotionally charged, and sometimes an advisory board can take the pressure off the office and or the supervisor, sometimes even the trustees, because you have some independent parties that give you perspective, and the minister might very well then want to deal with his advisory board and say, look, having consulted with my advisory board, I'm moving in this direction because they've given a broad perspective.
I hear you, and I understand clearly the kind of advice that would enhance the operation and the governance of the office. But what is troubling me is that what you are proposing to do is to set up an advisory board that has three different people that it is advising. So the supervisor is very, very separate from the minister, who is very, very separate from the office of the supervisor itself. And if you have one board that you're saying is put in place, and what you've said here is that this is the advisory board to the office of the supervisor, but it can't be advising the office of the supervisor and also the minister at the same time. You have to make a distinction between the two, because the supervisor must have that independence. You can't have the same people giving the advice on policy, and it's essentially policy that the board would be advising on in all the instances. Strategic business planning and responsibilities of the office could only be policy that they're advising on. They can't be advising on operational matters as an advisory board. So all of these are policy matters. I am suggesting a consideration of that approach, and perhaps it's not an advisory board to the office that you want. Perhaps you want an entity that exists in the matrix. We have different oversight committees that do insolvency whatever. I'm just saying, but from a governance perspective, for me, I would have some concerns about one board advising three different elements of the insolvency matrix who themselves should have some separation.
All right. I'll give you this, because I have to deal with it, both in private and now as a minister. I have 20 independent agencies. Some have advisory boards, some have boards of governance. You have to remember, though, Senator, that when advice is given, title passes. I want to say that so it's minuted. When advice is given, title passes. It's an advisory board. Wait, no, you're not in a position of conflict, because I sit and appoint boards for 20 agencies, because that's my responsibility. I'm not conflicted when I appoint those and they give me advice, or and they might not. You remember as well, you have to ask for advice. You might not ask for it, and when you get the advice, title passes. When you get the advice, you own it. You don't have to use it. What's a conflict?
The conflict I'm raising, the example of you appointing and them advising is not the same issue that I'm raising. Here you're asking an advisory board to advise three elements of the insolvency framework.
Right.
The advice that an advisory board would give to a supervisor in a matter related to how they operate their office, I can see may not always be consistent with the advice of the minister, because the responsibilities are vastly different.
Indeed.
So as a board member on that advisory board, if I am in a position where the minister has a duty to act in a particular way and the supervisor has another duty, how do I discharge my advisory function without feeling like I'm in a conflict? I just don't see how, because of the different roles that they have the same person advising them.
But it's
don't
interesting,
understand.
you're a lawyer, and you give advice to a lot of people. Sometimes some of them are in conflict. I mean,
No.
Just,
My advice can't be given to people in conflict.
All
That's
right.
exactly it. If I determine that there's a potential conflict,
you remove.
I have a
You remove
duty
yourself.
to remove
All
myself.
right, but may have a different position.
So I think you put the advisory board in that position if they are, and it's not to say that the minister and the advisory board are diametrically opposed. I'm not saying that. I am saying that there are going to be times when the minister and the supervisor may not be on all fours in a matter because of their different functions. How do you treat with
The
that?
advisor, let me give you an example of the board. When I run NCB or any other bank overseas, or when Don now runs Grace, Don has a board, a super board up there, where he sits and I think his Professor Shirley is the chairman. They have subsidiary boards. There is, what's the money collecting business? Western Union. There's a bank. There's a food business. There's a food business in Jamaica. There's one in the United States. There's one in England, all different boards. And the senior board at the top has to give direction, advice, overarching across that. The supervisor, the supervisor is, if I'm on the board, and the supervisor, I'm on the advisory board, the supervisor brings an issue to me, I address that issue as it relates to the supervisor. The minister were to call me next minute and say, this is the situation. Minister, I have just looked at the supervisory issue. If you go down that road, you're in serious conflict, and you should probably avoid going down that road. The minister doesn't have to take my advice. The supervisor doesn't have to take my advice. I'm in an advisory position. What I said in the mic wasn't clear? No, but she wasn't saying anything when I was speaking, so she will wait. So, so that is the example I have to give you. I might be asked this hour to advise the supervisor. Supervisor what rolls out that it is. I look at it. I might seek my advice from my counselor, whoever I want. I said, this is what I would advise you to do. The minister calls me afterwards and says, we have this issue. So, Minister, I just met with the supervisor. These are the details that I see. This is the advice I've just given. Yeah, and he can say, yes, I accept that, and matter is finished. If he has a different position, he might say to me what his position might be. I said, Minister, if you go down that road, this is where you're going to go and have a conflict. He is the minister. He can decide to accept my advice or not. So my job is to give advice. No, I've just focused on the supervisor. I started with the supervisor. Twice I started with the supervisor.
Let me try one last time to explain my concern. And I'm going to use the example of what happened in the Trinidadian Parliament a couple of weeks ago, where the Auditor General and the Attorney General found themselves in a situation where, Minister of Finance found themselves in a situation where they both needed legal advice. And because the Attorney General had advised the Minister of Finance, the Attorney General could not advise the Auditor General, so private counsel had to be sought. I am saying this is an advisory board. It's not a board of governance, but it is an advisory board. If I am giving advice, and the advice that I'm giving to the minister and the trustee and the supervisor, who is supposed to be independent of the supervisor, doesn't take direction from the minister. Supervisor, by the statutory framework, cannot take direction from the minister, and the minister cannot direct the supervisor, though the appointment may be there. Once the appointment is made, the supervisor has a statutory duty to execute his or her functions. So if there is something that the supervisor does in the execution of the duties, and there is an advisory board, there's advice by the advisory board to say to the supervisor, well, boy, in the scheme of what you're doing, this is our position. That action, whatever it is, of the supervisor may well be something that the minister and supervisor are not on all fours about. And I'm saying you cannot have the same person advising two people who may be on two different sides of the issues. It may not happen often. What I am asking you under this scheme, what is in place in circumstances where you find the supervisor and the minister at different ends of an issue? This advisory board cannot advise both. It cannot.
All right. I'm going to bring in two other people. First, counsel, and then Ms. Eaton wants to speak. But I want to just address one point you made, Senator Golden Campbell. The Attorney General is a creature of law and gives clear legal binding advice. Nothing that the advisory board does is binding. And in fact, the only relationship might be because the advisory board is not binding, that board moves between the three parties and can give clarity, but the advice is not binding. But let's move on to some other people. I'm going to go to Ms. Eaton, and then I come back to Mrs. Sutherland Reed. Ms. Eaton, and then afterwards, Mr. Gale, Senator Gale will come in. Ms. Eaton? Ms. Samantha Eaton?
Hello.
Yes.
Hello, good morning.
Yes, and she's from the Office of the Parliamentary Counsel, I think? Yes.
Yes, I am. I'm sorry, I'm just waiting for the camera to come up.
All right, here we are. We can see you now.
Okay. So my intervention in relation to this discussion was just to direct the members of the committee that perhaps they would like to look at Section 222 of the Insolvency Act, which speaks to the appointment of the supervisor. And the Act states that for the purposes of this Act, there shall be a supervisor of insolvency who shall be a public officer designated by the minister as such. And Section 223 goes on to set out the prescribed statutory functions of the supervisor. Now, who is a public officer? This is set out in the Constitution, and it states that a public officer means the holder of any public office and includes any person appointed to act in any such office. And public office means any office of emolument in the public service. So I'm just bringing the committee's attention to this in the perspective of the discussion that is being had in terms of the relationship between the supervisor and the minister. Thank you.
Just be a little bit more definitive for me. What is the point you're defining?
If I'm understanding the discussion, is there's a concern about the proposed advisory body.
That's right.
Providing advice.
The advisory board. The advisory board.
Yes, providing advice to the minister and to the supervisor. But the relationship between the supervisor and the supervisor is actually, from what I'm seeing here, it's a public officer. So that is within the ambit of the constitutional arrangements in terms of a department, in terms of being part of central ministry. That having been said, the supervisor has very specific statutory functions that have been conferred.
Right.
The other thing I wanted to state is that the advisory board, I have seen formulations where it's not so much advice as recommendations that may be made to, as you say, inform procedural approaches and policy development and so forth. So there is quite a variation among those kinds of bodies. It just depends on the functions that you intend to confer and how those are crafted as well.
All right. And before I bring in Mrs. Sutherland Reed, I am very clear, having worked in those areas, to know that the advisory board really just gives advice, and it has nothing to do with interfering with the responsibility and functions of either the agency or, in this case, a supervisor. But Ms. Sutherland, we had you, and then Senator Gale.
What I was saying. So there is no inherent conflict in the sense that it is recommendation, advice within a framework where policy directives comes from the minister in any case, and therefore those recommendations would be consistent with that.
Or that the advice is just that.
Yes.
It doesn't have to be,
accepted in either case.
at all. Senator Gale.
So 222 and 223, especially 223, is very clear and precise in terms of the functions of the supervisor. Now, this construct of an advisor board, is there any other insolvency legislation that defines this construct that we could examine in terms of its scope and functions? Because that may assist us in indicating that this is what applies elsewhere in another jurisdiction that is so applicable to inform us.
Yes. You speak in the mic, please.
Could do that research. I think, though, that this was based on consultation as to having other set of competencies to make these recommendations, which would be useful for this particular office. So I don't know
and the questions are fair from Senator Golden Campbell, but this is not a new construct, and it's not been seen to be obstructionist or objectionable. So do the research, come back, and let's see where we are on it. Okay? Next, continue.
That's it, Minister. The other pages are the regulations which were mentioned already. So that's the last section of the Act.
I can't believe it.
Yes.
I'm so pleased. Wait. Just I want to see some red writings here. Well, don't we have some other things here on the matrix?
That's a mention of the different regulations.
Okay.
I just put them there in
Delivery of documents, certificate of assignment, prescribed information.
all in the regulations and all mentioned before.
Those are just qualifications
Yes.
of trustees, that kind of stuff. So we are, in fact, in full review. There are two things now I remember we have to get to. We have to look at 202, which that's not the omnibus clause where you say all and everything and everybody. That's not the one?
No.
So 202 and then the all and everybody. Okay? Those two have to be adjusted, and then you'll do some research.
Section 156, 5.
Yeah.
156.
Just let me since you want to do the numbers, all right, I'll look at your numbers. Because we're looking, I know 202 by heart, that has to be reviewed. Let me look at 156. 156 deals with the include other methods of credit participation.
Yes, that is the all. Yeah.
This is the all and everybody. Yeah. All right, good. So those two, and then the advisory board. No, 156. Where before you came, Senator Gale, they were talking about how do you get advice out, and they said all methods, and I said, boy, somebody's going to sue you because every day AI is changing, and TikTok is going to have a new version next month, and so on. So you can't say that. You have to be more prescriptive, and then make an amendment that these will be amended from time to time, and it says by whom, so that there's an official note that goes out that, okay, we're including or we're dropping the media that we use to advise you. And then 202 will be amended, and then the advisory board will be researched. Any other matters that we need to look at? Thanks, Ms. Eaton, for coming in. thank you all for coming and participating this morning. I really appreciate it. I think we've got through quite a lot. Where are we now? I need to understand now a date for my bill to get to Parliament. That's my interest. Where are we?
So, Chair, that means we're at the point now where a draft report.
Yeah, that's why I'm asking my legal eagles on the Madam Clerk. The next meeting is July 4th. Why are you asking her to tell me? She has to tell me because she's the clerk, or you can tell me because you know. Yeah, but I know that, but you know too.
Okay.
All right, Madam Clerk, you go and tell us what is it?
No, Chairman, the next meeting is July
Yeah,
4th.
that I know. I'm not interested in that. I want to know when I'm going to get the bill. So it sounds like you two have to tell us.
Chair, I think what I would suggest and recommend, yes, there's going to be a draft report, but I would suggest and recommend that between the clerk and the technical team kind of go through.
I want a timetable because
right.
what I want,
And
I'm
then
going
that
from
report would come to the
I'm
committee.
going from where I want to get, which is the submission to Parliament, and you can work back to today and tell me what the timetable looks like. Are you with me, Mrs. Sutherland Reed and Mrs. Evans Roberts? So I go to the target and work back because I want to know when we're going to be able, within reason, to submit the bill in Parliament, given that we don't have complete control over everything to get it to Parliament. But give me a rough timeline so we can know when we expect it to go to OPC and wherever else it must go.
I prepare that for next meeting after doing the appropriate consultation.
Thank you. That sounds.
The report is to be prepared. I don't know the time frame. I would want to consult.
That sounds good to me. Any other matters to be discussed? If not, I'm going to accept next meeting date. Usually is sent out. When is it? The 4th of July. You can't forget when a certain election is taking place and a big celebration elsewhere is taking place. So I'm going to ask so that we don't have any more dislocations that Senator Kevin Gale moved for the termination of this meeting, seconded by Senator Golding Campbell. 10 o'clock is the time. Next meeting on the 4th. And thank you all so much for coming. Appreciate it, and we'll continue to do the work till we get the bill done. Yes, ma'am.
I know we're adjourned, but I just want to say it. I have to say it again, because this is the second committee that I am getting a chance to benefit from the work of the ministry, and I continue to remain impressed by the standard of how documents are submitted, the clarity with which they're submitted. It is so easy to prepare, and I just need to thank them.
Isn't that wonderful? And I certainly support that, and I'm very happy for it. Thank you, ladies and your teams behind you.
Mr. Chairman, I support that, and I want to recognize as a member of the private sector, I think you are doing an excellent, excellent job of chairman of this committee, moving things along, and I want to congratulate you on your chairmanship of this committee.
Yeah, man, come to SIP as well. We accept guests. You're welcome. But Senator Webby, I really appreciate your participation and your comments, and we really do want to get these bills where they are so that it can help the people who need the help. Thank you all so much again. Meeting is terminated.